Welcome to the Mulcahy Law Firm podcast. For over 25 years, Mulcahy Law Firm has helped plan communities and condominium associations throughout the state of Arizona.
The intent of our Zoom, Facebook Live, First Friday free call-in, videos, and podcast is to provide a forum for board members and community managers to receive answers to HOA and condo legal questions. Please note, the content of these sessions are general in nature and is not intended to and should not be relied upon or construed as legal opinion or legal advice regarding any specific issue or factual circumstance. You should directly consult with an attorney for advice regarding your individual situation.
Welcome to the podcast. Here's Beth Mulcahy.
Good morning, everybody. Welcome to our firm's live virtual First Friday for the month of March. Thanks so much for being here today for our third First Friday of 2024. Let me start out by just saying to everybody, I hope you're having a great month so far. First day. And it's my favorite holiday of the year, St. Patrick's Day. And when I was getting dressed this morning, I put on my St. Patrick's Day sweater. So hope everybody has a wonderful St. Patrick's Day. I won't be live virtually with you until after St. Patrick's Day. So I want to make sure I got that in this morning. Looks like we have a great number of people joining us here today, which is wonderful. Welcome, everybody. Thanks so much for being here today. We're just starting our first Friday for March 2024. We have a number of great questions, about just under 30 questions this morning. For those of you who haven't met me before, my name is Beth Mulcahy, and I am the managing partner of the Mulcahy Law Firm in Phoenix, Arizona. We have been doing First Fridays for over a decade, where we hop online and answer questions for free for board members, managers, homeowners that may have questions regarding our industry. During the pandemic, we switched over and started to do it virtually, and we are able to answer a lot more questions doing it virtually. So just in terms of my background, for those of you who may have never joined First Fridays before, I've represented HOAs and condominiums in the state of Arizona for the past 27 years. My firm currently represents over 1,000 planned communities and condominium associations throughout the state of Arizona. I also serve on my HOA board and have now for on and off for about 14 years. So welcome to our firm's First Fridays for March 2024. My name is Beth Mulcahy, and for those of you who have joined us before, you know that First Fridays is a great time to get your questions answered on HOA and condo law at no charge. So here's how First Fridays is going to work today. We already had you submit your questions, so we're not accepting any new questions during this presentation. Just a quick and friendly reminder that sometimes the questions are, they can be a little bit, if they're unclear, sometimes I have to just do the best I can with the questions. So hopefully they'll be clear. If I miss something, you're always welcome to email me and we'll try to figure it out later. Let's talk quickly about our Arizona legislature. They are in session, and, we are closely monitoring as a firm the bills that pertain to associations. This year's been kind of busy. There's been 29 bills pertaining to HOAs and condos that have been introduced so far, and we're monitoring all of those bills. I'm not going to get into the nitty-gritty of the bills because it's still early in the session, and maybe there's like 10 or so that are moving. And, the other 18 are either duplicates or they're just not going anywhere this year. If you are interested in learning more about the bills that are pending in this year's legislature, what I recommend that you do is take a look at our update that we post on our website. It's on the homepage of our website at mulcahylawfirm.com. And we give a summary to date of everything that's happening on the bills. And we just updated it again yesterday. Thank you, Andrew, in my office for doing that. And I took a quick peek at it last night. So that'll give you the most recent information about the bills that are pending this year. So I encourage you to take a look at that. We may also be sharing it with you on Facebook Live and Zoom, but if we aren't able to share it quickly this morning, you also always can find our legislative update cheat sheet on our firm's webpage. Let's get right into the questions. We have 28 questions this morning. The first one is from an owner. I live in a condominium community of 184 units. Our board has decided that they want the hired property manager on site 4 days a week and have set up an office for the manager in the community clubhouse, which means that when the manager is on site, residents cannot use the clubhouse. My question is, can the board make a decision like this, legally make a decision like this, to take away resident amenity for another community use? This is kind of a tough question. I don't have your CC&Rs, so I don't know specifically what your CC&Rs say about the clubhouse. I think this is a legitimate thing that your board has done. It's probably economical too, because they don't have to have, like an on-site office or an offsite office, nearby your association. I don't know how large your clubhouse is, if it, takes the entire clubhouse or if she just sets up on the table. I also don't know why maybe you can't still have mixed use in there at the same time. If there's an office, maybe that person could use. But legally, absent, is this technically a change of use? Well, the clubhouse can still be used as the clubhouse ever was used previously for parties or bridge or whatever, or maybe to go in there and read a book. But on the days that the manager's there, and I don't know if she's there 40 hours a week or if she's just there 1 day a week or 2 days a week, I'm not necessarily sure it's a change of use because the clubhouse can still be used in other ways. I would just say it's more of a mixed use thing. So short answer, I do think the board can legally make this decision. If you have concerns about it, though, go and talk with them. And maybe there can be some sort of accommodation that can be made. So next question from a board member. We have been with our current property management company since 2019. Can we demand that they submit copies of any and all communication records, such as emails, phone call logs, and notes that they have received and or replied to with our community? We're not looking to violate our homeowners' privacy, but we are finding that we are not being told about issues and requests from owners, and many of these things have now created legal liability issues, as well as challenges with our relationship of our board and our community members. And so the question is, who think that the board is being unresponsive? Okay, so bottom line here is your current property management company is not giving the board information, and they are required to provide you with this. I mean, these are your records. So I think what I would do is just tell them going forward that these things, any email that they receive, any phone calls, logs that they have, if they're not doing it, have them start doing it. And any sort of other notes that they may have, like any in-person communications that they may have, if the managers at the property need to be included in the board packet going forward. And this is a job requirement. So I would suggest that you do that. And they should be complying with that. I mean, they work for you. Okay, next question, number 3. Can an HOA have a binding arbitration clause in their CC&Rs regardless of the ADRE complaint mediation option available to them? So really good question. This is from a board member. The short answer on this would be yes. CC&Rs are a contract. And even though you didn't negotiate the terms of the contract when you became an owner in your association, you still are subject to the terms of the contract. There are some exceptions to this. Like, let's say that the contract terms are, they call it like an adhesion contract, that you didn't negotiate the terms of this contract because, you just love the house that you wanted to buy or you love the condo and you weren't able to go back and negotiate with the seller. Hey, I don't like this provision in the CC&Rs. I want this taken out of my version of the CC&Rs? That doesn't happen, right? You get what you get. You don't throw a fit. So you get the CC&Rs that are the community association CC&Rs. You can't negotiate them. Now, the next, question, if this was ever challenged in a court of law, is this, unreasonable that this would be in the documents? And I don't think it is. I've seen other arbitration clauses in many other associations' documents. And as long as it's fairly written, I think this is something that, can be done in a document and wouldn't be challenged. And the ADRE complaint mediation process would just be an add-on that, if you want to go that route, I have to look at how your documents are written. Maybe it says that this is the only way is to have an arbitration, like using the American Arbitration Association or something like that. And then that would preclude you from being able to go to Superior Court or Justice Court or the ADRE. And that is something I think that would be enforceable if it was part of the contract and it's reasonable. The next question is from a board member. When a property is sold and changes owners, we collect a transfer fee based on a % of the sale price. How should we calculate the fee when a property changes owners and there is no sale or sale price? For example, an inheritance. Okay, great question. So a couple things on the transfer fee, or sometimes referred to in our industry as a capital contribution fee. That needs to be in your CC&Rs and it needs to comply with Arizona law on this. We have a great cheat sheet on this called transfer fees versus disclosure fees that I would really encourage you to take a look at. It has to follow the specific language that the statute requires. For example, the fee has to touch and concern the land. It has to only go to the association's board. It can't go to a third party, et cetera. And so one of the things that is, should be in that writing is, what types of transactions qualify as a transfer fee, something that kicks in the transfer fee. And often, like for estate planning purposes, you're not charging a transfer fee. How do you collect it if there's no sale or sales? Like, let's say there's a beneficiary deed and the owner passes away and the property just automatically transfers to the owner's child. You contact the owner and just let them know, here's the provision in our CC&Rs that talks about transfer fees. And this event, transferring the property to you by beneficiary deed, is a qualifying event to collect a transfer fee. And this is how much you owe. If they don't pay it, then you probably want to get your attorney involved to write them a letter on it. Okay, next question, number 5. What are some things to keep in mind? And this is from a board member. What are some things to keep in mind if gate cameras with license plate recognition capability are to be installed? These are not actively monitored, but video is available if needed for crime investigation. How should access to the information be limited? Should a report of access be kept and made available? How to address privacy concerns? If video shows gate bumping, potentially damaging gates, is video footage sufficient for warning or potential fine and damage recovery? Okay, some things to keep in mind if you have gate cameras with license plate recognition capability. What I would recommend is that you have signage indicating that this area is being videotaped, and so that people are aware that this is happening. Number one. And you also may want to say that there's not somebody 24/7 monitoring it. Or you might actually want to put that in, like a newsletter or something, just to let people know this. I'm not sure I would put that on the sign, because if you've got people coming in to, take property or something in your association, you wouldn't want them to know that there's no active monitoring. Okay, so what are some things to keep in mind? This type of information definitely can be used to provide evidence to an owner or a vendor or a guest that they have damaged something at the common areas. If they, run the gate and, the gate hits their car or the gate breaks off, that video footage most definitely will be used as evidence, for whoever is responsible for the damage. And that will be used, if we go to court. Or maybe we send them the video footage so that we can prove to them that they were the ones that caused the damage. So I guess the one question would be, yes, can this be used? Of course it can be. How can this information be limited? I think a good way to do it is have a destruction policy on it. So maybe you can have the board approve it at a meeting, like we only keep the video footage for 30 days or a week or whatever you decide is a good idea. And how should the information be limited? Well, it's a book and record of the association. So if, you have it and it hasn't been destroyed pursuant to your destruction and retention policy, it's fair game for somebody to take a look at. Addressing privacy concerns, I think just having a retention policy that's reasonable, that you're just getting rid of it within a certain period of time. You don't have it after that time period. But otherwise, it is fair game because it is a record of the association. Okay, question number 6, from a resident who's interested in running for the board. If our HOA has a large special assessment, can the board collect donations and then use the money to pay the special assessment for those who cannot afford it? That's such a nice question. I love that. I've never had that question in 28 years. Yes, of course, the board can do that. We've seen that situation arise where there's a hardship situation and maybe there's one donor who pays for another person. Yes, of course, you can do that. It doesn't matter who pays for it. I'm sure that the person who is the recipient of that would be very appreciative. One thing you would have to be careful on is that the board wouldn't be able to just withdraw that and say that the board still has an obligation to collect the assessment from everybody. But of course, if there's a pool of people that are willing to donate money for somebody who's in need, the board certainly can accept that money and apply it to that account. Okay, next question from one of my favorite board members. During last week's HOA Academy Zoom meeting, Beth discussed open, executive, and emergency board meeting criteria and requirements for recording and posting meeting minutes. Is there any difference in the requirement to record and post meeting minutes for executive or emergency board meetings when the board is declarant controlled as opposed to homeowner controlled? I think I probably need to take a quick peek at the statute on that. So maybe if my team could just pull up the Planned Communities Act open meeting law, and then I'll come back to this question at the end. I believe, I don't want to say it without looking at the language specifically. So I will just, if you can pull the open meeting law statute and just put it right in the script here and help me out, that'd be great. Otherwise, I think I can look it up quickly too. Okay, next question from an owner and former 20-year property manager. Our membership passed our 2024 budget at the annual meeting. A line item in the budget was for an audit, which the ongoing board wanted done for tax year 2023 and 2024. Our bylaws state an audit every 3 years. We had an audit in 2021. The new board voted to do a review and not an audit due to cost. Can a new board decide without having the membership vote to amend this line item? Just ignore the passage of the budget, which was passed by membership with this line item. What can we do? Okay, so you have a lot of information because obviously you are in the industry as a property manager for 20 years, and now you're an owner in your association. Your bylaws state an audit every 3 years. So you had your last audit in 2021. So it does appear to be time to have another audit. Now, the question is, do your bylaws require an audit by a CPA? I don't know because I don't have your documents, but if it says that you have to have an audit done by a CPA, you would have to have this audit done by a CPA in 2024. Best practices would be, to have an audit by a CPA. Even if your documents don't require it to be done by a CPA, general accounting principles would say that if your documents say you have to have an audit, it should be done by a CPA. So the new board voting to not do it due to cost is concerning because your bylaws do state that you have to have an audit every 3 years. I guess a workaround for the board would be to, have, an audit done, not by a CPA, but that's very dangerous because they don't have the expertise. I don't know who would be doing it. Maybe there's somebody with some sort of financial expertise on your board or, on a committee or something, but I would be opposed to that. My feeling on this, if the board was consulting with me, would be your bylaws say you have to have an audit. This is something that you can't do. You can't not do because you're supposed to have an audit every 3 years. It's the third year and you didn't have it in 22 and 23. So this is your year to have it. So having the board do a review and not an audit due to cost, or you're violating your bylaws because your bylaws say that you have to have an audit. Best practices would be to use a CPA to have that audit done. So what can you do if your board's doing it this way? I think I would talk to them and say, hey, I talked to an attorney. I went to this free call-in. This isn't our attorney. This is just somebody who's talking about this topic. And they said our bylaws say we have an audit requirement and that every 3 years, and we haven't had one, and we need to have one now because we can't contradict our bylaws. You could go to the ADRE, Arizona Department of Real Estate, and file a complaint against the board trying to force them to do that. You'll have to pay the filing fee, and to find out more information on that, you would just Google the ADRE and HOA disputes, and it'll pop right up the form that you have to fill out to make a complaint with the ADRE. There is a $500 filing fee, but you get it back when you win because you will likely win on this. Okay, next question, number 9, regarding a board. We have a number of homeowners with weeds and tree trimming issues, about 10% of our owners. We send them a notice every 2 weeks, and we are fining them $100 every 2 weeks. Some owners are up over $2,000 owed. They don't pay and they don't maintain their yard. We can't afford attorney's fees to take them to court, but we want the community to look nice and keep up our property values. Even if we take the $500 ADRE route, we'd have to have extensive attorney's fees. Our CC&Rs do not have a self-help option. What would you suggest? Oh, you read my mind. Okay. You as a board can go to the ADRE and file your own complaint against the owners. You don't need to have an attorney. The forms are very simple. You will have to front the $500 ADRE filing fee, but it is an option. But if you have 10% of your owners, and I don't know how many total owners you have, but 10%, it could be a lot of owners, right? So you're going to be fronting the $500. All the forms for the ADRE are right on the Arizona Department of Real Estate website. So it's not like it's pretty simple process. And I mean, you've laid it out in the question really well. You could probably just put that right in the ADRE. If you can't afford attorney's fees to take them to court, you as a board can go to the ADRE and file a complaint. That would be a good way to do it. You could go to small claims court and file a small claims action against them for the fines. You don't need a lawyer in small claims court. That's obviously another option. You also, and you don't have self-help, so you can't go in and clean it up. You might be able to amend your documents in the future to give you some additional remedies, like self-help, to go in and clean it up. Those would just be a few thoughts on how to best handle this. Okay, next question. Is a ballot legitimate if there are 3 separate sheets of paper with the signature page being separate? Do the results of the vote need to be recorded in the minutes of the association, such as for or against? Thank you. Okay, so lots of times we see ballots with multiple pages, especially if there's a number of amendments or a number of issues being voted on. I don't have an issue with the ballot being multiple pages. It would be nice if the ballot said like page 1 of 3, page 2 of 3, page 3 of 3, like in the corner or something, but it's not necessary because typically the vote on it will say like, I vote to amend section 2.4 of the bylaws, and then it has a signature line, et cetera. So I don't have an issue with that particular issue for this question. Do the results of the vote need to be recorded in the minutes? I think that's a good idea. If a meeting of the membership is needed to have this vote, the meeting minutes for that event should be, indicate, it passed or it failed and what the final tally was. If you don't need a meeting of the membership, I also think it would be a good idea after the meeting to put in a future board meeting what happened and the numbers, just so that there's a good paper trail for future boards. Okay, next question, number 11, from a board member. Election question about write-in votes. We had 93 homeowners for a 9-member board. 3 are elected yearly, 24 returns needed to meet the quorum. This year, only 2 candidates are on the ballot. Can a single write-in name be elected to the board? So short answer would be yes. So if you have 3 positions open and you only have 2 candidates that are write-ins, you only have 2 candidates that are already listed on the ballot, and then, you have a line for write-ins. If there's only 1 write-in and, there's only 2 candidates that were on the ballot and then 1 write-in gets written in, yes, that person is elected. The ballot does not mention writing in a candidate's name. Ballots are opened and tallied at the annual meeting in March. I mean, even if the ballot, I guess what I would say on this one, it's kind of a tough call, but don't you want board members? So, I think I would think that you would, even if someone wants to challenge it saying there was no line for write-ins, this person apparently is interested in being on the board. The board may want to appoint them to the open position. But I would say if there's no prohibition on write-ins and you didn't talk about it at a board meeting before the annual meeting saying no write-ins at this annual meeting, I think that the write-in candidate could be elected to the board. Remember, we're not trying to keep people off the board. As a matter of fact, it's hard to find people to be on the board. So, this is a good thing, not a bad thing. Okay, I'm just going to switch back to the Planned Communities Act to answer that one question that we had. My great office put the statute right in on the script, so I have it right here. So the question was, during last week's HOA Academy Zoom meeting, Beth discussed open, executive, and emergency board meeting criteria and requirements for recording and posting meeting minutes. Is there any difference in the requirement to record and post meeting minutes for executive or emergency board meetings when the board is declarant controlled as opposed to homeowner controlled? Okay, the big question is, when the board's under declarant control, do we have to still follow the open meeting law? So I'm going to look at 33 Arizona Revised Statutes 33-1804E, and it says, notwithstanding any provision in the declaration, bylaws, or other community documents. So, what that means is no matter what the documents say, this controls. For meetings of the board of directors that are held after the termination of declarant control of the association, all of the following apply. So basically then it goes into the agenda shall be made available to all members. It talks about emergency board meetings, it talks about a quorum, etc. So, here's what I would say. Best practices would be that if you're under declarant control, best practices would be to provide that notice to the owners for regular board meetings, executive session board meetings, and, just best practices would be to do that. But under the statute, you just so you don't have to necessarily comply with this particular law because it talks about under subsection E that some of these things don't apply if you are still under developer control. But again, best practices, in my opinion, would be to do it, even though the law may not require you to do that. Okay, so let's see is there any difference in the requirements to record and post meeting minutes for executive or emergency board meetings when the board is declarant controlled as opposed to homeowner controlled? So remember, executive session meeting minutes are never, to record and post meeting minutes. So executive session meeting minutes, remember, are never given to anybody other than the board. So that's important for us to talk about here. Emergency board meetings, remember, just a quick little rule of thumb on emergency board meetings is emergency is something that you can't wait 48 hours to notice the meeting. And it's only, used when you can't wait 48 hours, right? The decision has to be made. It's urgent. Under declarant control, this particular statute, there's a carve out for you that you don't have to, comply specifically with the emergency meeting things. However, best practices, in my opinion, would be that you handle it this way and you do still comply with the statute, even though you may be under declarant control and you don't have to. Okay, next question from a board member. Do HOAs still pay property taxes on common areas? In the past, a very small amount has been paid for property taxes, but around 2019, we noticed that we aren't being billed anymore for property taxes. Did something change? Even the assessor's website shows 0 property taxes owed. So I'm noticing a couple things. So I'm noticing that in the question that you gave me, you're indicating that you are condominium. And so that's something that I think is, important for the facts here today. I can't use the name of the association because we don't do that for First Fridays. So in a condominium, the association doesn't pay taxes on common areas. How the taxes work is that each owner owns an undivided interest in the common areas. If you look at your deed in a condominium, let's say there's 100 units in your condominium and you own 1 unit. Your deed will say that you own, let's say, unit 1, which is your unit number, plus a 1/100th interest in the common areas. And so when you pay taxes on your condo, you're paying your proportionate share of taxes on the common areas. So for a condominium, the condominium doesn't get a bill for taxes on the common areas. In an HOA or a planned community, that's a little bit different. The association owns parcels and they do have to pay taxes on those parcels. Now, earlier in my career, probably sometime in early 2000s, maybe even late 1990s, the assessor's office, there was a law passed that changed the valuation of the common areas in a planned community or HOA. And it put a valuation of $500 on, so let's say you had 5 tracts, so tract A, B, C, D, E. You would get one of the bills would be for tract A, let's say, and it would be valued at $500. It's just a flat valuation. And then all those other tracts, B, C, D, E, would all be combined with tract A. So you only have one tax bill typically, and it's very low because the valuation of the property is $500. So it's like somewhere like $5 or $10 or something like that each year. But that's only in a planned community. Just mentioning, based on the nature of this question and how you've submitted this, I don't think that you're going to be paying taxes because you're considered you are considered a condominium. Okay, next question. Question number 13, somebody who serves on the architectural committee. My understanding is that the parking issue is being resolved or being revised by the legislature. No HOA can vote on the parking and will be under the new law. HOA will not have a say in parking requirements. Okay, so really good question. Last year's legislative session, there was a bill that pertains to planned communities who have streets that are dedicated to the public. It talked about like if your association was created before January 1st, 2015, I think, that you have to have a vote by, 2026 to whether or not you want to continue being able to regulate parking, on-street parking on these streets in a planned community where the streets are dedicated to the public. There's a bill this year that totally reverses that bill from last year. So this is kind of going to be a gray area that we have to keep an eye on. I would suggest you take a look at our cheat sheet for the new legislation in 2023, or reach out to my firm, reach out to me by email at bmulcahy@mulcahylawfirm.com, and I can send you a copy of the law. For right now, that is the law for associations. But stay tuned because it looks like there might be some fine tuning on that, and they might switch it back because there's been a lot of unrest about it. So stay tuned on it. Right now, that is the law, but that could change here in this legislative session. Okay, question number 14 from somebody who is on the finance committee. If an HOA is professionally managed, what financial documents should the management company provide to the board each month? Quick answer on that would be in the board packet. There should be copies of the bank statements, a year-to-date budget, a financial statement for the association, delinquency list, any sort of reserve accounts, CDs, information about when the CDs are coming up for renewal. Those would be the most important things that should be provided to the board in the board packet every month. Would the same financial package that the board receives be given to the finance committee? Best practices probably would be yes. I think that if the finance committee is there to help your community, this is something that it would be a good idea for, I don't know the role of the finance committee in your community, but I can't imagine why you wouldn't be able to see this. And you also could be able to see this if you made a records request as an owner. So how does finance package differ from what is posted on the HOA web portal available for all members? There really shouldn't be anything that's different. You should be entitled to see basically all the items that I just said, with the exception of the delinquency list. You wouldn't be able to see, even if you're the financial committee, I would say that you shouldn't be able to see the delinquency list. Or if there's any sort of litigation pertaining to the association, on collection matters for owners that aren't paying assessments, you wouldn't be able to see that either. But generally speaking, the finance committee could request all the other things like the year-to-date budget, the bank statements, the financial statement of the association as a homeowner if you're not getting it as a finance committee. Okay, next question, number 15 from a board member. Does an emergency repair require full board approval? Okay, so we're kind of getting into that emergency zone, right? As in terms of what's considered an emergency. So you're calling it an emergency repair, so I'm assuming that we can't wait 48 hours to make a decision. When you have a true emergency, make best efforts to get a quorum of the board to vote on it. But if you cannot get a quorum of the board and it's a true emergency, your fiduciary responsibility is to act in the best interest of the association. And so you should, with as many board members as you can, make the decision quickly to move forward on the item. And then remember, if you're having an emergency board meeting, you should be taking minutes. At the next regularly scheduled board meeting, you should read into the record, that you had an emergency meeting, why you had it, what was decided, and attach those minutes to the next board meeting minutes. So there's a paper trail on what happened. Okay, the next question, number 16. In updating our CC&Rs, the question has come up regarding section owner responsibilities for their property. Should the term limited common property be used in that section for better clarity? It's yes. I mean, I like the idea of using like limited common areas or limited common property if you actually have that type of thing in your association. I mean, we got to look at there's a kind of a full analysis on this. We have to look at the plat too, because if the plat defines something as common areas and that every owner has, the right to enter into the common areas and use them for their benefit and enjoyment, we have to keep that in mind, right? If you have limited common areas, and a good example of this would be like an enclosed balcony or a patio area that not everybody else is using. I'm not opposed to using that for better clarity if you're amending your CC&Rs, but we need to do a 360 look at that, 360 degree look at it, look at the plat, look at the property, what exactly, is this area? Is it really a limited common area, et cetera, before we would make that change in the CC&Rs. Okay, question 17, for somebody who's running for the board. Our association is using this section in our CC&Rs to use the reserves as a slush fund for any pet projects they want that they did not budget for in 2024 and have already spent $100,000 between January and February board meetings. Can you use the reserves for unbudgeted reserve expenses and operational expenses not budgeted for in this way? I don't know enough about what's going on in your community to give a good answer on that. So I got to go with what your information that you're providing to me. So reserve funds, in my opinion, should only be used for reserve items. So if it's listed in your reserve study, then that is like a long-term capital improvement type thing. And it's listed in your reserve study that you've had done by a professional reserve company. That's how the money should be used. If you're borrowing money from the reserve to pay for operational expenses, that's not a good thing. You should be talking to your CPA about this because you likely have to repay that in the same fiscal year. And maybe they know that they've already done that because they're doing it early in the year, taking the money, and then they're going to, pay it back later in the year. It's just an example of probably not very sound business practices for your association or desperation, like they just have no other choices. So it's not customary and it's not something that I would recommend. But talk to the CPA to make sure that legally you are, returning the money within the same fiscal year. And if there are any other requirements, the CPA can give you. Okay. And again, I wanted to make it clear, I'm not in favor of doing that. I don't think that's a good idea. It likely, could get the association sued in the future for, using reserve money for non-reserve items. Okay, question 18 from a board member. If a board of directors has 4 board members and therefore doesn't have a quorum, is it considered an illegal board that should not be allowed to perform its duties? Is there even such a thing as an illegal board? Note that no owners came forward last year to apply for a board position. Please advise the best way to respond. To owners who think our board is not legitimate, thank you in advance. The one thing I really need from you is to find out how many board members you have. I have to go by the fact that you're saying you have 4 and you don't have a quorum. So I'm guessing that your board is 9, because 5 would be a quorum. If the number of board members in your bylaws is 5, though, just because you don't have 5 board members doesn't necessarily mean you don't have a quorum. I mean, you have a quorum with 3. It's a 5-member board in your bylaws. So it's hard for me to answer this question, but let's just say, for example, you are a 9-member board and you only have 4 people and you wouldn't have a quorum. So I guess a couple things to think about would be, can you amend your bylaws to make it a smaller number board? If you don't have any owners that came forward last year to be on the board, another option would be to have, like, our firm send out a letter to all the owners saying, this is what's happening. We don't have a legal board because we have less than a quorum. And if we continue down this path, we won't be able to get any business done this year. And also we won't be able to conduct any business, pay any bills, et cetera. And a receiver will need to be appointed to manage the affairs of the association. And if that happens, that's going to cost our association a lot of money. And see if we can get somebody to volunteer to be on the board after receiving that letter, knowing that that's going to affect property values. Having a receiver, it's going to end up, a special assessment to pay for the receiver is going to be levied by the court. And it's just all around not going to be a good situation. So my thoughts on this would be, send out that letter from our firm warning them that, hey, we're going to have to go into a receivership. Change the bylaws to make it fewer number of board members is another good idea. Okay, question number 19 from a board member. If a HOA board is getting training by the association's attorney, what part of the open meeting exceptions would allow this training to not be an open meeting that the public can attend? Okay, great question. So Legal advice from the attorney for the board of the association is the exception under the open meeting law that would apply here. A board training is going to be getting advice from the attorney, and that clearly would fall under this category. Okay, question number 20 from a board member. We have 2 LLCs in our community that are not paying their monthly dues in a timely manner, which is creating an increase in delinquencies. What action can the HOA legally pursue? Okay, great question. LLCs, so limited liability company, there is a different analysis for those types of properties. Why? Because typically, if you get a judgment, so there's 2 ways to collect money from a delinquent owner. So you can get a personal judgment against the owner, and that's just a piece of paper saying that you owe the money. And with that, we can garnish their wages, their bank account. If they have rental properties, we can garnish their rental properties to pay back the debt that's listed on that piece of paper. So one option to collect a debt is, get a judgment. Typically, it's done in justice court if it's under $10,000. Another way to collect that debt is to foreclose the assessment lien, and that's a more serious remedy. We go to Superior Court to do that, and we take away their property. We get the judge to order that because they haven't paid their assessments, that there should be a share of sale of the property. The tricky thing with LLCs is we don't know. Sometimes people have single property LLCs, and so if we get the piece of paper judgment against them, it might mean nothing because, maybe they don't own any other properties in the LLC's name and they don't rent it and they don't have a bank account. Or if they do, there's no money in there. And so with LLCs, typically what I'm thinking of, and we do a lot of collection work at our firm and we're good at it. I mean, I love collection work. It's just been something that I've always done since 1996 when we started our firm. And we continue just to get better and better at it over the years. When I'm looking at a file on an LLC not paying assessments, my mindset would be that I'm going to go to the assessor's office. Does this LLC own any other properties? That's good to me because we might be able to get a judgment against them and then garnish the rent. Maybe it's like a company that owns a lot of properties, right? A limited liability company. I know that there's going to be a path for me to collect money because they own a bunch of properties and they're probably rentals. So if I get a judgment, I can just go and garnish the rent of one of those rental properties. But more likely than not, the analysis that I'm doing is this is an LLC. As soon as they hit the threshold for foreclosure, which is going to be 1 year delinquent in assessments or $1,200 in assessments only owed, we're just going to foreclose. Because with LLCs, we don't always know about their assets. It's too risky. The best way to get the money, if there's equity in the property, is just to foreclose. So you have options, of course. You can go to justice court, get a judgment against the owner. If it's under 10 grand, if it's over 10 grand, you go to Superior Court to get a personal judgment, or you can go the foreclosure route. And like I said, more likely than not, our firm is going the foreclosure route because there's so much uncertainty with the LLC's assets. Okay. And we put in the chat, we put a cheat sheet on this, on the best way to collect delinquent assessments, our secrets to collecting assessments. So take a look at that. And it's also listed on our webpage at mulcahylawfirm.com. Okay, question number 21 from a board member. May we charge a fee for failure to submit an architectural form before starting a project, even if the homeowner submits the form after receiving the warning letter? Homeowners aren't requesting approval first because they end up with no penalty if they just go ahead and then submit the form after the work is done or when they receive notice. Honestly, the way I would handle this would be I would just levy a fine against them for not following the procedure outlined in your documents. Under the law, we have to give notice of the violation, which would be not getting time approval prior to doing the project, architectural project. Give notice of the violation, an opportunity to be heard, which can be send us an email with your response on this or come to a board meeting, and then we levy the fine. That would be how I would handle this. And, make it kind of hefty, like $200, $250, $500, depending on how serious it is. Under the law, it just has to be reasonable. Okay, next question, number 22 from a board member. Our board would like to interview landscaping companies in person in a work session, executive session. No votes would be taken and all discussion would take place at an open meeting, at which time we would make a motion and vote. Is that possible? If not, is there a way we can interview landscaping vendors in person without involving the whole community? A way we can gather information that we can discuss in an open meeting? So really great question. No, a quorum of your board cannot interview a landscaping company in person in an executive session. So the key thing is a quorum, right? So that is going to be, in my opinion, a violation of the open meeting law because it doesn't fall into any of the categories. So the way around this, the workaround, the loophole would be either do it in the open session, right, which I'm understanding you don't want to do, or have less than a quorum, have that meeting with them to, privately interview them. And then the less than the quorum can report back to the board their findings in an open board meeting, and then the board can vote on it at an open board meeting. Okay, question 23 from a board member. We have one position available at our annual meeting in April. A current board member is running for re-election. Posing this current board member is a new applicant that the current board members think would be a great addition to creating a more functional board. What, if anything, can I do to try to sway public opinion towards electing the new candidate? Okay, you're the board president, actually, because I see that from the notes. What can you personally do? Let's see. So a couple of thoughts. Okay, as president, you really can't be getting involved in the politics like this. What you can do as an individual board member or individual owner is you can vote for this person because you think they are the best person. If there's some sort of a community-wide effort to elect this new board member, the new applicant, who everybody thinks is going to be a good person, there's all kinds of ways to campaign. But if somebody, creates a campaign flyer and says all of these people, think that this person would be a good candidate, you could sign as an owner. I wouldn't put that you're the president on there because you have rights as an owner and then you have rights as president. As the president, you shouldn't be getting involved in this at all. As an owner, you have the right to vote for the candidate that you like, and you have a right to say that, you as an owner, you support that candidate, but I wouldn't be the leader putting the word out there. It's too close to you as the president. You have to work with all these people, no matter who gets elected. And I think it's in your best interest to not be the ringleader trying to sway public opinion. If you want to sign it as an owner, you certainly can. And you can vote for this person as an owner, but I wouldn't be the person that's the ringleader trying to get the current board member off and the new member on. Let somebody else take the lead on that. Okay, number 24 from a board member. We are unhappy with our management company and want to have an executive session to discuss options and a plan for researching alternatives. I know we have to post that we are hosting an executive session, even though it is not open to homeowners. Do I have to tell the management company what the purpose of the meeting is? Okay, a couple of thoughts on this. You're on your board and you can go into executive session to talk about job performance of your current management company. Okay, but you can't go into executive session to talk about options and a plan for researching alternatives. So what I would recommend is that less than a quorum, just have an informal meeting to discuss that. This seems to be a topic that needs to be done in an open meeting, but I know you don't want it in the open meeting because then you're going to give the, telegraph to the current management company they're getting fired, and it's going to create a bunch of problems. So I'd probably just have one person on your board talk individually to the other board members and get their feelings on it, and then have that board member, probably the president, reach out to our firm if we're your attorney, or another firm, whoever your attorney is, and talk about what our options and plans would be. And then continue to communicate with the other owners, the other board members that are less than a quorum. You can do that. That's not a violation of the law. In an open board meeting, you can have your first discussion on it kind of after behind the scenes and less than a quorum has discussed it. I think that's probably a legitimate legal way to handle this. Okay, next question, but get your attorney involved because firing a management company is tricky. When to know when it's time to leave, how to leave, et cetera, how to find a new management company. So I have a lot of good tips on this. We also have prior classes that we've taught on this that are on our website, on our videos. Go to mulcahylawfirm.com. I know last year we taught a class on this exact topic, and it might be a good resource for you as you're going through this process. Okay, question number 25. If an item or rule is listed in the CC&Rs, can the HOA board suspend violation notices and fines for those homeowners not in compliance with the CC&Rs? And if so, for how long? So really the ability to suspend CC&Rs Can the board suspend violation notices and fines for those homeowners not in compliance with the CC&Rs? And if so, how long? I'm a little confused here on this one. I think what you're saying is, and my team's everybody's talking about this internally right now, and they're emailing me, is can we suspend voting rights? I think that's what you're asking. So if you want to suspend voting rights, it has to be in your documents. Is it in your CC&Rs? Typically, it's in your CC&Rs or your bylaws, more likely in your bylaws. Do you have the right to suspend for violations? So you can only do that if it's in your documents. If the question is, and this is a good example of, I don't understand the question based on the way it's worded. If the question is, can we not, enforce something that's in our CC&Rs? Like, let's say your CC&Rs say no sheds, and you're wondering, can we suspend violation notices for sheds and fines for owners? I would say no. If it's in your CC&Rs, you're required to enforce it. Okay, question number 26. Our master association is in the process of amending the CC&Rs. The president of the master has called a special meeting of the board of directors to hear the amendments and revisions being proposed by the committee charged with reviewing the document. Special meeting is for information only. No other business will be conducted. Is it necessary that a quorum be declared and that minutes be taken for this meeting? If there is not a quorum, does everyone just leave? When would the minutes of the meeting be approved? Okay, so you're in the process of amending your CC&Rs at your association. It's your master association. And the president's called a meeting of the board to hear the amendments and the revisions being proposed by the committee. No other business is going to be conducted. Do we have to have a quorum? Now, I don't know on this. Are you meaning like a quorum of the board or a quorum of the members? So if it's just a board meeting, it would just be a quorum of the board. I feel that you should have a quorum of the board there to, make the meeting go forward. You could still conduct a informal meeting if, there were some extenuating circumstances that you couldn't have the board there. You could just say this is just an informal meeting because we can't get a quorum and we're just going to go through the amendments just to get everybody up to speed on them. That would be okay as long as it's clear that it's informal. I would still take minutes, whether it's formal and you have a quorum or informal, because, we want these amendments to pass. And we want to have evidence that we have shown the amendments to the people and talked about them as a board. And this was a process that's been ongoing in our community for a long time, and a lot of thought has gone into it. So I would take minutes no matter what. And then when would the minutes be approved? Minutes are always approved at the next regular board meeting. If it's a board meeting, if it's a meeting of the membership, at the next regular meeting of the membership. Okay, last few questions. We've got about 5 more questions. So question 27 from an HOA member. Our bylaws require 5 board members: chair, vice chair, secretary, treasurer, member at large. Can the offices be combined, such as chair, secretary, member at large, treasurer, vice chair? Still 5 officers, still all 5 offices covered. Nothing in the bylaws or CC&Rs prohibit this. Is there any state law that's on this? No, there is not a state law on this, and that should be okay. But just be careful. Don't stack one person too much. Like the president shouldn't be the secretary and treasurer too, right? Because that's too much. The 2 most difficult jobs, in my opinion, are president and treasurer. So if you have that person, one person being the president and the treasurer, that's a very large responsibility for one person. I'm not going to say I'm opposed to it, because sometimes it is what it is. You can't get anybody to do it. But I'm just going to say that person's going to be very, very busy in that year when they have both of those responsibilities. Okay, next question from a manager. Great. Thanks for being here today. Is there any way to prevent investors from buying into a community? Short answer would be probably not. Generally speaking, probably not, right? There are some things that you can do that could make it more difficult for them, or that could make it unpalatable for them to buy in. Some things that come to mind would be to pass an amendment to your CC&Rs that requires the property to be owner occupied for a year. So if it's an investor, they would lose rental income for a year. Or amend the documents to make the minimum rental period like a longer term, like 12 months or something, that, maybe an investor might think, that's going to make it hard for me to rent this place. Okay, 3 more questions have been added. So we're going to finish up with the last 3 questions here. Let's see. The first question is number 29. It's from a board member. We're a community of over 600 homes. Okay, nice large community. What do you think about the property management company automatically approving or disapproving some architectural requests so that the architectural committee never sees the request? Most of these are paint requests where we have defined paint schemes, but the schemes are years old. Also, the architectural committee has not had a meeting in 2 years. Okay, I'm not opposed to the routine requests being automatically approved by the management company. The way to set that up would be to have the board and the architectural committee sign off on it by voting on this at a meeting, that any paint requests that are submitted by an owner for an approved paint color can be automatically approved by the management company. What I would do is at the next board meeting or whatever, or whoever, I mean, it sounds like you have an architectural committee, but they're not having any meetings, which is concerning. You should be approving by acclamation. There should be like a consent agenda with all of those, and then you should just approve it. So there's a paper trail. We had 45 or 60 paint applications in the past 2 months. And by acclamation, the management company already sent the approval letter because they're painting the approved paint color. But by acclamation, we're reaffirming the approval as the architectural committee or the board. Something that kind of concerns me about this is that your architectural committee hasn't had a meeting in 2 years. For an association with 600 homes, that's weird, because I bet you have a lot of applications for architectural changes. So you need to get that architectural committee acting again, reviewing applications and meeting on a somewhat regular basis. If that starts to happen, then maybe the architectural committee will be reviewing these. And maybe only the ones that come in between meetings, the management company approves. If it's an approval of something that's like an approved paint color or something that is for sure going to be approved based upon the conditions that are in your architectural guidelines or whatever. Be careful on this. Having the management company doing everything, if there's a mistake and they disapprove something that they shouldn't disapprove, or they approve something that never should have been approved, the fingers are all going to get pointed back to the board and the architectural committee, and it could get really nasty and ugly with the lawsuit. So follow corporate formalities. We have a great cheat sheet on architectural committees that I would encourage you to look at. And I think as a board, you have to determine hey, is this architectural committee working? Is it actually functioning? Maybe this is something that the board should act as the architectural committee. And remember, one board member needs to chair the architectural committee under the law. Okay, last 2 questions. Number 30, from an owner, we are a self-managed over 55 HOA. We have 184 members with a semi-public pool. Currently, the insurance liability coverage is $6 million. Do you believe that is adequate, or should the limit liability be increased? If you feel it is not adequate, what amount of liability insurance would you recommend? You're kind of a smaller association. You have one pool. It seems at first glance to be enough coverage, but really the person you need to ask this to is the association's insurance agent. I think they're the ones that are best qualified to determine how much liability insurance you should have for your community. Okay, next question. Let's see. So the HOA transfer fee and disclosure fee is not to exceed $400. We're in the process of moving to a different HOA complex. The transfer and disclosure fee there equals $400, plus I received a bill for an additional $400. Is this legal? Do I have to pay the second bill? Okay, so really hard for me to comment on this without looking at your documents. What I would recommend that you do is look at our cheat sheet on transfer fees and disclosure fees. You can find that on our webpage at mulcahylawfirm.com. I think we may have also already shared it in the comments section here today. So what I would recommend is, so the disclosure fee is set up by state law, and the maximum on that is $400. So that probably is legitimate. And you likely do have to pay that with the new purchase of the new home, right? In a different HOA complex. The second one for the transfer fee, that's a little bit more complex. I don't know what they're basing that on. Like I said earlier in the presentation today, any sort of capital contribution fee or transfer fee really should be in the CC&Rs and set up in accordance with state law. There's state law that specifically addresses what you need to have in the CC&Rs for the transfer fee. or capital improvement fee to be valid. I mean, it is kind of a small amount, $400. So you might be able to rely on the Nonprofit Corporation Act, which allows a de minimis fee to transfer the property from owner A to owner B in the association's records. I mean, I think de minimis, in my opinion, would be like $100, not $400, but I don't know enough about your association. So what I would do is, you're likely going to have to pay the disclosure fee, right? Because that's set up under state law and the max is $400. That's probably legitimate. On the transfer fee, what you may want to do is ask the seller, can you provide me with where in the CC&Rs it gives you the authority to charge the transfer fee, and see what they come back with. Okay, that's it for today. Thank you for joining us for our firm's live First Friday virtual event for March 2024. Looks like we got through all the questions in an hour and 9 minutes, which is wonderful. Thank you for being here today. It looks like we had a very good turnout. So thanks everybody for showing up on Zoom and Facebook Live. Just a friendly reminder, don't forget about our next virtual HOA Condo Academy class on Tuesday, March 19th from 11 a.m. till 12 p.m. It's class number 4 of our 2024 virtual HOA Condo Academy. And the topic is going to be a really good one, turning challenges into triumphs, some strategic solutions for HOA and condo woes. So basically, this is the class for you if you have problems in your association right now. We're going to analyze the most common problems facing association. And some examples would be like, how do we handle, we don't have enough money for our association? How do we handle our aging infrastructure? We don't have enough money to fix, all the problems that we have in our community right now. What do we do if there's fraud and embezzlement in our community, or we suspect fraud and embezzlement? What do we do if we have difficult owners that are causing us to want to quit the board? What about the management company? What do we do if we've got a bad management company or our board doesn't get along? We're going to cover all the challenges that I've learned in the past 27 years representing associations. And we're going to give you some great practical advice to help you navigate them. So hope you'll join us on Tuesday, March 19th for that very important class. My favorite holiday, my maiden name is Mulcahy. And I have strong ties to Ireland, and I will be celebrating with my family on St. Patrick's Day. So I hope you have a great St. Patrick's Day too. Take care, everybody. Have a wonderful weekend. Be safe, and look forward to seeing you on March 19th. Take care.
Don't forget, our free cheat sheets are available for download at mulcahylawfirm.com. Please go to iTunes or your favorite podcasting platform and leave us a rating and a review.